Hello, I'm Oliver Bullough. I think I am now live. I'm very sorry that I'm not there in person. The difficulties of COVID are still sadly with us, but I'm really pleased to be chairing this panel, not for publication, how lawyers and reputation managers enable legal intimidation and slaps, which is an issue that is very close to my heart, not least because I'm currently being targeted with legal proceedings in 2 different countries. It was 3, now 2. And I think probably in common with pretty much everyone else on this panel and probably on most of the other panels, I have received my fair share of extremely aggressively phrased letters over the years from people who are paid much more than me to make sure that I don't write about their clients who are paid even more than that. We've got a really great panel here today. And the way we're going to do this is I'm going to introduce our panelists, and then they're going to spend 6 or 7 minutes talking about the issue. And then you're going to send in questions via the Q&A app. Please do so as you go along at the end. Whenever you think about it, anything that occurs to you, please send it in. And I'll combine the questions you send in with things that I think we should be talking about. And all together, I think we're going to have a pretty fascinating hour and a bit. So our panelists are in order that they're going to be speaking. Franz Wild, finance editor, experienced and award-winning journalist, previously for Bloomberg and now at the Bureau of Investigative Journalism. He is their lead on the Enablers Project, which was launched in the summer of last year, which investigates how top-paid business executive lawyers and political advisors in the UK are enabling oligarchs, dictators and criminals around the world. A lot of mainstream reporting has been done on the crimes, abuses and financial misdeeds of malicious foreign states and wealthy individuals, but very little, not enough, not nearly enough has been brought to light about the lawyers, PR advisors, accountants, estate agents and bankers and so on that take care of the details and help them get away with it. So Francis is going to speak first, followed by Manuel Delia, Maltese blogger and freelance journalist. Started out as, in his own words, a political operative in the Maltese scene and press secretary to the Prime Minister. Since 2013, he's been analysing what's happening in Malta, and I think we can all agree there's quite a lot to talk about there. Other than that, after that, sorry about my pronunciation, perhaps in this, Therese Dakar, advocacy coordinator for the Amabugane Centre, how am I doing, for investigative journalism, which means dung beetles. Perhaps she'll talk about why they name themselves after dung beetles. A small team of investigators who's done probably greater impact than most groups of investigative journalists in terms of forcing information to the public domain, which have contributed to all sorts of changes, including not least the resignation of a president. Not many of us can say that. And then last but very much not least, Nicola Solomon, Chief Executive Society of Authors. I should declare an interest. She's very much helped me in the legal cases that I've been facing. She's a solicitor by trade, but joined the Society of Authors 10 years ago and does a lot of work advising authors on how to manage legal problems. So, France, I think we're going to start with you. Would you like to kick off and tell us your thoughts on lawyers, reputation managers, and the general enabling industry, why it's such a problem and what we can do about it?
Yeah, thank you, Oliver, and thanks for having me here. Just very briefly, a bit about me, because it'll help you understand kind of what I know and what I don't know. I worked for Bloomberg for over 10 years. I was based in various African countries and Democratic Republic of Congo, Ivory Coast, and South Africa before I moved to London about 5 years ago. And over the period of my career, I've been sort of drawn more and more towards reporting on corruption, and that kind of started in Democratic Republic of Congo, where I started noticing that all these sort of weird mining deals were happening, and it wasn't really entirely clear what was going on behind the scenes. And there's quite a small community of journalists and NGOs and other people who are quite interested in making sure that transparency remained a thing. And over the last 10, 15 years, that's been quite successful, but we've obviously also faced a lot of pushback from the people we're writing about. And I think the best way to illustrate this is kind of an example, really. And that example, my sort of most vivid example, was about 2 years ago when I was writing an article about a gentleman called Dan Gertler. and he had acquired a mineral asset in the Congo, and there were question marks around, well, how did he get this incredibly valuable mineral asset? Dan Gertler is under US sanctions. The US government believes that he has paid $100 million in bribes to Congolese officials, including the former president, Joseph Kabila. That's something he denies. He says he's not done anything wrong, but that's the claims of the US government. So we were obviously curious as to how this individual came about these assets, and we researched an article about it and amassed quite a lot of new information. And then it got to the point of going to him and kind of asking him about this. And so we did this. He has a PR agency in London. They're called Powers Court, or at least were. And so we approached them and said, well, what about this? Are we missing something? Do we understand things incorrectly? Could you help us get to the bottom of this? And instead of the press agency responding, we got a letter from their lawyers, Carter Ruck, a very long letter marked private, confidential, not for publication. And, immediate, probably 6-7 pages by memory. I haven't looked at it for a while, but there was no attempt to answer any of the questions. And to be clear, the questions were, very straight-laced questions. I was working for Bloomberg at the time, and there's no space for innuendo or supposition or anything like that. It's very much fact-based. So we got this letter, and all of it was basically alleging that we were sort of out to get him. We're not interested in the truth. We had a vendetta. It was that sort of stuff. And then also basically questioning, well, where did our information actually come from? As most of you know, it's not always safe to kind of talk about your sources. And particularly if some of your sources either are or interact with a place like the Congo, where the rule of law is maybe not quite the gold standard, you might understand that it's not always safe to do that. So to cut a long story short, this turned into quite a long back and forth of legal letters. With our side kind of saying, well, we stand by our reporting, these are the questions, and can we engage with the questions, please? And the other side saying, well, no, you need to tell us where your information is from, and by the way, we think this is it, and this is why your information is wrong. But never dealing with the actual substance of what we're trying to write about. Always dealing with, well, we believe that this is your source, and your source isn't credible for this reason. And what this basically turned into is a process of about a year long before we could actually get the article out. And thankfully, I was working for Bloomberg, which is an incredibly well-resourced organization, and stands behind its journalists and is able to kind of see this through, and also has extremely experienced and able lawyers who could assist us. So in the end, the information got out there. But what happened was there was the kind of something that started out as being a sort of essentially what the press is we're kind of representatives of the people. Everyone serves their role in society. Well, our role is to get information for other people who are too busy baking bread or making clothes or whatever. So we do represent the public, and so this conversation that was meant to be in the interests of the public, in the public interest, was kind of forced into the private sphere. This may sound like a sort of extreme example, but what's great about a place like Bloomberg is walking around the newsroom there, you bump into all sorts of journalists, and also at the Bureau of Investigative Journalism, where I am now, all the people there are always working on stories that are trying to expose wrongdoing by sort of rich and powerful people and corporations. And so this is not an isolated incident. This is par for the course. And traditionally you kind of always hear, oh, well, you've got to be careful about libel. You've got to be careful about defaming people. Well, nowadays it's a lot broader than that. It's turned into, well, you've got to be careful about not breaching their data, not violating the Data Protection Act. You've got to be careful about not violating their privacy. There's a whole gamut of things that you've got to be careful about. So that's the experience. Just to emphasize, this is a live case. Next month, Bloomberg, in a case that I've got nothing to do with, is in the Supreme Court arguing a case about privacy and at what point a journalist has the right to write about someone who's under investigation. At the moment, the latest Court of Appeals judgment suggests that you can't write about an individual if they're under investigation, unless they're someone like sort of Boris Johnson. But there's a whole sort of tier 2 or tier 3 layer of people, individuals, who need to be held to account, where transparency and accountability are essential, and that doesn't happen if journalists aren't able to write about them. I'd like to leave it there and have some questions later on. We can't hear you, Oliver.
Sorry, that was me muting myself to prevent me disturbing anyone with my chat, which I did rather better than I'd anticipated. Sorry, you're on mute after all being the words of the year. Manuel, yes, we're now going to have you talking about the situation that you have faced in Malta, please.
Thank you, and thank you, Justice for Journalists Foundation, and thank you, Foreign Policy Center, for this important and timely discussion. I will share with you my personal experience of SLAP suits, or at least a sample of them, to try to throw light on what happens when a self-publishing blogger working on their own must be prepared to face when covering stories of financial crime and the organizations that perpetrate it. My name is Manuel Delia, and most of my work is published on a near daily basis on my blog. It used to be something I did on the side, but it became a full-time job the day a Farbate journalist was killed by a car bomb in Malta in October 2017. I resolved to help fill the void she left, not by journalism of the same quality, that would have been impossible for a novice like me, but at least with commentary and noise. 6 months later, I published a story about a bank operating in Malta that had only been set up 4 years earlier. I had solid information, doubly confirmed, that Maltese investigators had been tipped off about previous investigations by other agencies into the conduct of the owner of this bank. And I published that report in April 2018. I was called in by a firm of Maltese lawyers and told to retract the story and expunge it from the record, or I would face a lawsuit in the UK, where the same Bulgarian-born owner had other business. I had written in Malta about a Maltese bank operating in Malta, but I was threatened with a lawsuit in the UK. As I hesitated for a few days, I got a call from one of these lawyers. He may have meant this as a friendly aside, but he told me his client was serious about filing in the UK, and if he did, I wouldn't have to look for a defense team. I would better look for a cliff high enough to jump off. I gave in. I had only been at this for 6 months, and this bank was a sideshow in comparison with reporting about Daphne Caruana Galicia's case. But just 6 months later, Maltese regulators froze the bank's activities. Thousands of people whose only money in the world was trapped inside the bank suffered severe hardship for months before their money was released. I wrote an apology on my blog to all those people. Had I had the courage to stick to my April story, they could have been warned and banked elsewhere. But I had lost my nerve, and they suffered as a result. More than a year later, longer than the limit allowed by Maltese law, the bank's owner sued me in Bulgaria. As evidence about the defamation he suffered, he produced his girlfriend, who said my piece worried her about her man. Presumably the fact that his bank was shut down and was fined €3 million for systemic anti-money laundering failures did not worry her quite so much. The European Centre for Press and Media Freedom funded my defence, but I lost the case and I have since appealed. In May 2019, together with my co-authors, John Sweeney and Carlo Bonini, I was wrapping up a book about Daphne Caruana Galicia's murder and our Hercule Poirot-like list of suspects of possible perpetrators. I sent summaries of our findings to the Prime Minister of the time, Joseph Muscat, his wife, his closest advisor, and 2 of his ministers, inviting them to send in the responses to be included in the publication. They did not reply directly, hiring jointly instead the UK law firm Carter Ruck, who sent a flowery cease and desist. That letter ensured no publisher in the UK or elsewhere would touch our book. If you could write in a book that you suspected a Prime Minister in office of corruption, which could be a motive for a murder, the publishers asked us, why are they still in office? How are they not arrested? Fair question, except this was exactly why Daphne had been murdered. Luckily enough, we found a Maltese publisher mad enough to print the book and the Justice for Journalists Foundation, who funded the project. A month later, Joseph Muscat and his government collapsed. I am not claiming causality, but the collapse of Joseph Muscat meant that a UK publisher was then happy to publish the book internationally. That's the chilling and thawing effect in action. While writing to Joseph Muscat et al., inviting them to send their comments, I also wrote to one Jorgen Fenech, sending him direct questions that heavily implied suspicion of his involvement in the murder. I believe that was the first time, if not the only time, he was directly confronted by a journalist about the killing of Daphne Caruana Galizia. He hired a local to say warnings of hellfire should be considered to publish, which we proceeded to ignore. 3 weeks after the publication of the book, Jorgen Fenech was arrested, charged with murder, and he is still detained awaiting trial. Again, I do not imply causality, but I rather suspect he does. The noise from the local lawyers was just advance artillery. Much later, I would learn Jorgen Fenech consulted ACK Media Law in the UK and drew up a strategy to silence journalists reporting on him, his business, his past, and his present. His lawyers in the UK identified me as an easy target, not backed by a corporate structure and clearly unable to afford a defense. The lawyers advised Jorgen Fenech to use the UK courts to claim from me any risk of increased cost of borrowing from UK banks to his businesses. The plan was to send me a bill for over £70 million. That would have been my last coffee. From prison, he did not follow through. Instead, he uses his local lawyers to harass me, file personalist court complaints that single me out, and recently a lawsuit claiming a denied right of reply. His lawyers are prepared to do all this and more for their client of apparently inexhaustible resources. They have been charged with attempting to bribe another journalist to secure good coverage for Jorgen Fenech. They deny any wrongdoing. One final remark on enabling lawyers. These firms enable the crooks paid from their huge pockets, some of which we often rightly suspect is made up of proceeds of crime. But lawyers also enable us. My experience is also of lawyers who work for no charge, reading my stuff to warn me against more obvious pitfalls, and defending me in court when the slaps smack. They remind me that even in the anarchy that we live in, some light shines bright. Thank you.
Thank you very much, and good to hear you talking about the European Centre for Press and Media Freedom, which is doing a lot of good work helping journalists out. The Rory Peck Trust as well, obviously, which is also helping people. It does seem that there's this core problem of businessmen, politicians who are very wealthy and don't really care whether they win or lose a defamation case, and they don't really care whether they have costs to pay at the end of it. The issue is more just making sure that you get tied up in paperwork forever, as France was at Bloomberg, though admittedly it must be nice to have Mike Bloomberg as your backup. Jerez, would you like to talk about your experience in South Africa and how your team has faced and dealt with this particular problem?
Thank you very much, Oliver, and thank you to the organizers as well for giving us this opportunity to speak about our experiences. I'm quite struck as I'm listening to Frans and Manuel about the parallels, even though, you know, we're a continent away, a completely separate continent. But to kick off, I'd like to give a bit of context about Amabungane. We are a non-profit investigative journalism unit based in South Africa. Very importantly, we have no ties to the UK. That includes we don't have offices, we don't have any employees who work in the UK, we don't investigate UK-based stories. We're quite a small organization, there's 12 of us, and some would say that we do punch above our weight. We've produced some award-winning journalism stories that have investigated corporates and corporate wrongdoing, as well as corruption and malfeasance in the highest levels of government. We have in the past investigated alleged corporate malfeasance by a South African-based group of companies. And I'm not going to say their name, I'm just going to call them the group. They were founded by a local business person who, for these purposes, I'll call the founder. We reported on the company several times over the years, but in 2020, we became aware of some claims that the South African operations of this company had been starved of capital in order to fund offshore interests. And in addition, the International Consortium of Journalists, or ICIJ, provided us with information that provided us with leaked financial records that formed part of the FinCEN files. And they concerned the group and the founder. The record showed that Barclays Bank had in 2015 submitted a suspicious activity report in relation to the group and the founder. These concerned the character of financial flows within the founder's empire. The ICIJ emphasized that such reports were not proof of wrongdoing. So our journalist, Micah Reddy, sent questions to the founder, setting out the allegations and requesting comment. And what we got in response was very unexpected. Instead of answering the question, we got a letter from a law firm based in the UK. I'm not going to name the firm, I'm just going to call it UK firm. They sent a legal missive alleging that Amabungane was part of a conspiracy or being used by others as part of a conspiracy to discredit the group and the founder, and demanded that we account for how we came into possession of the information. They said that publication in the UK was sufficient to ground jurisdiction, and that they would not hesitate to seek the intervention of the court if the article made use of improperly obtained confidential information, contravened UK or EU data protection law, or defamed their client, which is exactly what France mentioned, ticking all the boxes that now tend to get ticked. This was very bizarre to us. As mentioned, we're an online publication, but we don't have any UK connections. Why would they send English solicitors to threaten us with legal action in the UK? Well, the answer is, of course, is why we're all here. This was obviously a slap threat. We know that UK litigation is very expensive, but in particular in South Africa, our currency is very weak against the pound, so there was the additional sting of that. And we also know that the UK's laws in this respect may be, let's call them somewhat retrograde. South Africa has got very robust constitutional protections for media freedom, and the issues like defamation involve a very careful balancing of rights. You would have heard Dario's presentation earlier. The highest courts in the land have affirmed these principles. So we feel comfortable publishing in South Africa, but the UK is a completely different terrain. So when we looked at this, we said, even the costs of successfully defending a case like this and getting a favorable cost order getting a favorable cost order would still not be enough. We would still be very much out of pocket. But we were concerned, we were not daunted, and we decided to stand by our reporting. We didn't want to back down. So the first thing we did is we mustered as many resources that we could. We're very grateful to have received guidance without charge from the Foreign Policy Centre, from the International Lawyers Project, and from a London-based QC who provided an overview of our concerns. And then we had another very important arrow in our quiver. We had the benefit of the expertise of leading South African media law expert, Dr. Dario Milo, who you heard from this morning. And he's also very well versed in UK law. And so we, through Weber Wenzel, which is the firm which Dario is with, And I also want to mention that Weber Wenzel has an alliance with Linklaters, which is reflected on the letterhead, and Linklaters also made some offers of pro bono assistance. So through Weber Wenzel, we engaged with the UK firm, basically denying that we had contravened any laws. We denied that jurisdiction had been established, and we said we had acted reasonably by balancing the public interest against the founders, alleged corporate interests in our reporting. The UK firm asserted that the jurisdiction would be established due to the proximate cause of harm arising in London due to the presence of Barclays Bank being there, which is where the suspicious activity report was generated. It also, again, adding another kind of layer to the issues that they wish to bring. Alleged that we had engaged in criminal activity, and they encouraged us to distance ourselves from the ICIJ, basically insinuating that if action was going to be taken against the ICIJ for dealing with these leaked reports, that we would be lumped in and face liability as well. They also told us that they were going to be briefing a South African-based law firm, which I'll call SA firm, to address South African law. So our response to this, on our advice of our attorneys, was actually to publish. We published the first part in the two-part series on our own website and through another financial publication called the Financial Mail. And this prompted a change in tack. The Financial Mail now got a letter from the SA attorneys, basically saying that the group and the founder should have been offered an additional right of reply prior to the reprinting of Amabungane's article, which is of course absurd. But they also descended into personal attacks. They attacked our journalist Micah, using statements on his social media accounts to draw unsubstantiated and incorrect inferences, and basically calling his character into question. At the same time, the UK firm had been directing thinly veiled threats against the ICIJ, suggesting that it was in collaboration with Amabungane, who was driving, and I quote, a hostile agenda against the founder and the group. Very sinister, apparently. We've then published the second part in the series, and then it took a further turn into the absurd. The South African lawyers demand that Reddy confirm whether he'd been in possession of an anonymous character assassination internet book that had been peddled across the media. We don't know what this book is about, but they were trying to allege something else, which we don't know. We hadn't spoken to that, we just left it at that. And that was the last in the correspondence for quite a while, until the Foreign Policy Center asked us to write an article about these experiences for World Press Freedom Day, which, as you know, is the 3rd of May. So we wrote to the UK firm telling them that we intended to publish this article containing some of the allegations, and basically saying that the article would basically reflect that that this was a slap threat, an attempted slap against us. UK firm responded very promptly, saying this is for our own interests. We're responding on our own, in respect of our own interests. They said that we took a one-sided approach, and that very ominously, it's for the judiciary to decide whether any claim succeeded or not. This is an interesting point. They noted with academic interest that their correspondence could not be a slap, because the purpose of a slap is to deter publication, and because neither Amabungane nor the ICIJ was deterred, this couldn't potentially be a slap, and therefore our argument was a theoretical abstract, which is very interesting. Responding on behalf of their clients, they took the same threatening tone, saying that we shouldn't make the mistake of believing that legal action would not be pursued. And then they said our letter was then forwarded to the SA firm. From the SA firm, we received a 20-page letter. That letter had obviously been typed up and they were ready to hit send the moment they heard from us again about this matter. And it set out the complaints of their clients in almost excruciating detail, going almost line by line through Reddy's article, and saying they added again another additional potential charge. They said we had breached South Africa's press code, so we could then be potentially hauled before the press council. Interestingly, the director of communications responded as well, basically giving a response to the questions about the alleged slap. and saying that this needs to be included in the article in full. So on the one hand, they were threatening us in the UK and South Africa, and then on the other hand, they were exercising the right of reply, which was also unusual. But by this time, we had sunk so many resources into the matter, not just the legal fees to Weber Wenzel, but the time of journalist, journalist Micah Reddy, our managing partners who were involved in every step of the legal aspects, as well as mine in writing the article and having it reviewed, that it just wasn't sustainable for us, even just based on the threat of South African litigation, to proceed with publishing. So out of abundance of caution, we put the article on ice and it's not been published. So the outcome of this is, while we didn't bow to the initial slap threat, when we tried to talk about that slap, the doubling down by the founder of the group was enough to overwhelm our resources. And we've already, as I mentioned, we're very small, and it wasn't feasible for us to go through this process again. So I just want to say that we're very grateful for the guidance offered by many people all over the world. But the unfortunate situation is nothing short of an offer of legal representation in the UK would be enough to give us a complete sense of security in publishing on this issue. And as we know, the situation is that there aren't enough resources such as legal NGOs and lawyers willing and able to work pro bono on this. So it is a very serious situation, and we hope that the law will be amended, making it more difficult for law firms in the UK to bring spurious slap threats or assist in recovering the costs, as Dario said, almost on a punitive basis, to make sure that the costs really are recouped. Without that, many critical voices will be silenced. Thank you.
Thank you for that. That's obviously, being someone from Britain and in Britain, an astonishingly troubling thing to hear. I've heard other stories from friends who work in outside the UK who've faced these kind of issues, but that's a particularly grim one. I can only apologise on behalf of my country. Really, weirdly, the situation used to actually be worse before 2013, hard though that is to believe. And yet it's still, the reform passed then is still very far from ideal. Now, turning to the UK, we've got Nicola Solomon. This is, I suppose, an issue we often think about as largely being confined to affecting journalists, but of course it affects anyone who writes things down or indeed speaks publicly about people with wealth and power who don't want their secrets to be revealed. So, Nicola, would you like to talk about how this affects your work at the Society of Authors?
Yes, thank you. And thank you for inviting me to be here. And thank you to the other speakers and the chilling things that they've told us, all of which is sadly not a surprise in this country. Perhaps I should start by saying something about the Society of Authors, so you know the background. The Society of Authors is the UK's trade union for writers. We've got around 11,700 members, and we advise them in all sorts of ways. So we do lobbying on their behalf, for example, for the Defamation Act and others. We do events and educate them, but we also offer a service whereby we vet their contracts at a very early stage. We'll give advice at any stage, not like poor Oliver once something's happened, but right from the beginning. And because of that, we see well over 1,000 publishing contracts a year. And the publishing contracts we see add a great deal to the problems that we see that journalists see here, for various reasons. And it's to do with the chilling effects that we've talked about. One of the things that we need to think about is something that Manuel said. He said that Carter Ruck's letter stopped any publishers touching his book. And one of the reasons for that, one of the reasons it's even worse for books than for journalism, is once you've published a journalistic article, it's out there, it's done, it's mostly these days on the internet, it's actually quite easy to take down. But if a book contains something in it which is considered defamatory, even if it's only one sentence about one person in a whole book, and you have to scrap the whole print run, then that can be fantastically even more expensive than the lawsuits. So people are very concerned about printing, even in these days, much more short run printing than they would be. And that makes them even more cautious, which is, of course, not good for public participation and not good for the kind of work, investigative work that people want to do. And we in contracts see things from the beginning which make it very much more difficult for authors. The first is that most contracts we see will contain indemnity clauses, which means that the author will indemnify the publisher against anything, any legal action they have against them, but any claims that are made, whether or not those claims have any merit at all. And that means that an author has to be really, really careful, because not only do you have to cover yourself, as we've seen, against justified claims, but against unjustified claims as well. And many authors are not represented by agents and certainly don't have lawyers on their publishing contracts. So publishing contracts are incredibly in publishers' favours. If we do see those, and if we see them on something which is likely to have, is being published in fact because it's giving a revelation about somebody, we will suggest to authors that they ask for reverse indemnity, that the publisher, who after all is going to get most of the money, indemnifies them, or that at least the claims language is taken out. But very often that doesn't happen, and that has a huge chilling effect. Another thing that is complicated is about insurance. Clearly, it's usually the publishers who are insured, not the authors. If we see these kind of contracts, we will ask that the author is added as an insured on the publisher's contract. But if that happens, and then as we see in SLAP cases, that a claim is taken just against the author, even if they're named insured on a publisher's policy, if the publisher is not sued as well, then that author will not have the protection of that insurance policy, which means that, that at the moment, authors would be advised to take out their own insurance policies, but that's ridiculously expensive. We know from research that we did in 2018 that the median income of a full-time professional writer is around £10,500. And the average earnings that an author gets from a book, any book, is about £6,000. If that's the case, you're not going to take out insurance. You just can't afford to do so, particularly because if you're taking out insurance on a one-by-one basis, it's really expensive. It's much cheaper for insurers if they're doing the spread betting for publishers, where there are very few claims. So at the moment, we don't have a situation where authors can get insurance. As we've heard, it's very hard to get legal advice. And authors are looking at, is it worth the trouble and the massive time it takes to defend something, or are they going to do what Manuel or Therese said that they have to do in the end? As they say, it's not sustainable to proceed. We've got an abundance of caution, said Therese. Oliver talked about aggressively phrased letters from people paid more than me, which I think sums it up beautifully. And Manuel talks again about the chilling effect. And really, there is no way around it. And the chilling effect on authors is perhaps even more, which is why books are often safer, because publishers also won't touch them. And we need to get publishers who, if they want books with revelations, that they've got the right to rely on proper checking by their authors, but they should be asking for indemnities that are narrower, and they should be taking on a lot more of the risk, and they should be prepared to stand by their authors, because otherwise we really don't have the way for things to be published if we know that people are going to take claims against them. And I'm just, before I finish, going to put on a different hat and say something slightly different around the things people have said about UK law, because in one of my other roles, as Oliver said, I was a lawyer before I went to the Society of Authors. I'm still a lawyer, and I sit as a judge in the county courts. I don't do defamation claims, but I'm a deputy district judge, and I see how judges apply the law right the way across all sorts of claims. And we might be thinking not so much about asking for changes of law, but asking for lawyers and for judges to be trained to use the law that we have in the way that we're meant to use it. When the civil procedure rules were changed, we started by having an overriding objective. That's part 1 of the civil procedure rules. And it says that they're a new procedural code. They have an overriding objective in enabling a court to deal with cases justly and at proportionate cost. And they set out what justly and proportionate costs includes. And one of those, literally A of our Civil Procedure Code, says that we have to ensure that the parties are on an equal footing and can participate fully in proceedings, and that parties and witnesses can give their best evidence. It says we have to save expense. It says we have to deal with cases in ways which are proportionate to the amount of money involved, the importance of the case, the complexity of the issues, and the financial position of each party. And we have to ensure that cases are dealt with expeditiously and fairly. So judges are subject to an overriding objective to make sure that cases like these, people do have the right to be treated fairly. We do need to look at their financial position, and in my view this really isn't happening. So perhaps before we look at changes of law, we should be looking at judicial training. We should be looking at the fact that when cases are to be struck out, and at the moment you can only strike out a case if there's no real prospect of success, but no real prospect of success is defined now as something that is more than fanciful, is a prospect of success. We ought to be getting judges to be more robust about striking out cases at an early stage when it is clear to them from a common sense point of view that those cases are only being brought to stop people speaking. We should not be allowing parties with a massive amount of money to make people stop taking their cases because it's not sustainable to proceed. That's not the overriding objective. Tells us as judges that we shouldn't allow that. And I think that before we start looking at changing the law, we should start maybe about looking at judicial training and a bit of protesting about whether the law is being applied as the overriding objective said it should have been. Thank you.
Thank you very much, Nicola, and thank you everyone for all of your thoughts. That was really interesting. We've got about half an hour now to chat. If you watching or listening have got any questions, please put them in the Q&A box. We've got a couple of coming already. The more the merrier, as far as I look at it. I'm going to start off though by asking, first of all, Franz, to talk about what happens when a letter arrives. I mean, no, and it happens to me, but I'm wondering, to you, if you're about to publish something, if you've asked for comment from someone, and a letter arrives from one of these many law firms, which we appear to be not naming, but Carter Ruck has been named, but as we all know, there are plenty of others. I once had a slightly awkward moment at a law firm in a lift when I was going up and realised that one of the people in the lift was the mother of someone at my son's nursery. And she never actually mentioned that she was the enemy. But there you go. She'd always been perfectly friendly. So, Franz, what happens when you receive a letter? What's your response, and how does the newsroom and the team respond?
Well, before I answer that, I actually had a very similar situation with a parent of someone at my son's nursery as well. It wasn't a lawyer, it was someone I was writing about. I had no idea that that their child was at my son's nursery. Usually, I mean, also often, so initially I, as the reporter or journalist, I send out the questions, and then sometimes the more proactive lawyers will respond to me and copy in our lawyer, and often copy in the most senior person at the organization. I mean, usually not, in Bloomberg's case, not Michael Bloomberg, but possibly the editor-in-chief. And you do get some comical situations where they don't actually know the email address, so they just put anything in. It just sort of sounds ominous. But basically they try and punch this up into a big thing. You then immediately sort of go and speak, so it gets shared internally to sort of lawyers and senior editors, and everyone has a look at it, and then you kind of huddle around and go, okay, well, what are we actually dealing with? How serious is this? Are they actually addressing our questions? Are they actually giving any information that has an impact on the actual story? And if that is the case, then obviously we take that very seriously, and we go away and either do more reporting or go, okay, well, these are aspects we can't actually write about. But then often, if it is on depending on, and this is where the kind of a judgment call comes in. So sometimes the decision will be made, well, we need a legal response, so we'll have a lawyer sort of write back. In other cases, we'll just say, okay, let's just have the journalist write back, which I actually think is preferable, because ultimately, you know, this is a journalistic enterprise. This is not, the aim of the game isn't to kind of have lawyers kind of hashing it out. The aim of the game is to pursue something that's in the public interest, and the way you do that is by having a non-legal discourse.
Manuel, so for someone who doesn't have the backup of in-house lawyers and so on, how does it work with you then? If you receive your email goes ping, and you've received a letter with one of these scary letterheads, you know, how do you respond? What's your process?
Well, you have to remember that the first thing that usually follows is a conversation with my wife, because any risk, any liability risk is for someone like me a completely personal affair. I write in my own name. It's not just that I'm not backed up by a structure, I'm not fronted by a structure. There's no company that sort of keeps a separation between who I am and what I own and the risk that I'm facing. So it can get a bit hairy. The experience was a bit different when I was writing the book, because I was writing it with two very experienced journalists. One spent many years facing this sort of thing when he worked at the BBC, and the other one worked at La Repubblica in Italy. And when we got, you know, an aggressive letter from a UK law firm, I sort of felt the confidence rubbed off from them, that they sort of said, this is exactly what you'd expect when you're accusing someone who has the means to respond in this way of the sort of things that we're accusing them of. So I think really the answer to your question is it's trying not to allow the text to overwhelm you. Try to see through this. The second question I ask myself: am I wrong? Is my journalism wrong here? Are they right? So I really need to take into account what they're saying. But normally, if they're right, they can just say so, and that's the end of the story. They're hiring big lawyers like that to scare you off, because they aren't. I'll just mention something which was not my direct experience, but which I witnessed. The week Daphne Caruana Galizia was killed, the owner of another bank on which she reported a lot sent these legal letters from a Washington law firm to all newsrooms in Malta who had covered the story after Daphne broke the story. And when they worked out the simple calculus of defending the case, even the largest news organization in Malta thought it made sense to just pull the story down rather than take the risk. That was tragic, but it was even worse when I realized a couple of months later, it was my story, that the same banker did not challenge Daphne Caruana Galizia in the same way. He simply opened a lawsuit in Arizona, claiming $40 million of her. She never found out about it. She was killed before she was notified of this. But you see there that it is not just because of the very extreme situation that I am in, because I write on my own. In a country like Malta, which is a country where billions of euro flow, and there are 31 banks, only 3 operate locally, the rest are bankers for the world, the largest news organization, Times of Malta, would not be able to defend itself from a lawsuit like this. So the risk here is really of overwhelming all journalism in Malta, and there's at least one episode I can think of where the perpetrator of this managed.
Great, thank you, Manuel. Well, I'd just like to compare, there's a couple of questions coming which I'm going to come to in a second, but I thought before we get to that, I'd just like to compare the experience of South Africa with a constitutional right to freedom of speech and the UK without that. Just wondering how you prepare a story for publication. Therese, if we could ask you first, what kind of checks do you have to do to a story before publication? And then Nicola, if we could come to you afterwards to see how that compares to the UK. I'm just interested in terms of what you would normally do when you expect something to only have resonance in South Africa. What do you need to do? Oh, hang on, I think you might be like me on mute, Joyce.
Sorry. Yes, I was just saying that we're quite rigorous internally when it comes to preparation of stories. So we have a managing partner with a lot of, over 30 years of experience and experience kind of batting off legal threats as well. So that there's an internal process of, the journalist writing. It goes through edits. And I think that's a particular strength that we have, is that we're very careful when we're doing the preparation of our stories. With that said, we don't submit every story, and they can be quite hard-hitting stories as well. As we said, targeting some of the powerful political and corporate elites. But we don't submit every story for legal publication. We've now only recently just established a bit of a kitty for pre-publication review, but this was definitely not a regular process. It's something that we've had to do in response to a number of legal letters coming in, but more on the South African side. But in doing so, we're actually quite confident in defending ourselves. We've, as you would have seen by our publication, we don't back down, because we know that the judiciary has in the past really recognized that balancing aspect in relation to freedom of expression. So we approach it with quite a bit of confidence, and if it's really something of concern, we've got Dario that we refer to and can get that kind of extra level of confidence. But I think in this particular circumstance that I described, the UK element really threw us into a bit of disarray because we were very unfamiliar terrain. And so that was a unique experience. But even, later today, we've got, a meeting about another South African a lawyer coming to us and saying some outrageous things. So we just confident in that respect, but definitely the international element is something that we're not confident about. And also it underscores our vulnerability in that respect when you're dealing with international lawyers.
Yeah, sadly that the case is rather different. I actually wrote an article about a book that hadn't been able to be published because it was being sued by lawyers, and then the same lawyers then approached the newspaper. So the article about the fact that the book couldn't be published, which just says it all really for me. Anyway, Nicola, the situation in the UK, what do you have to do before publication, to try and insure yourself? Obviously there's a sort of insurance, very expensive insurance post publication, but what's the publication process? All of this sounds a little bit like a sort of employment process for lawyers, really. But anyway, what's the pre-publication process?
I imagine it isn't so different, because we would expect everybody to rigorously check their stories and rigorously make sure that they've got their sources lined up and that they know what they're doing. I think, though, the difference in the UK might be that there is a bigger awareness of the people who are likely to sue, and that actually then you might take even more care, and your publishers might take the view that they won't take it forward if that's likely to be a risk, whether or not you can prove what you've said, unless you can really show a lot of public interest. And one of the things that's complex in books as opposed to articles is that they tend to be longer and have a wider scope. You'd expect a bigger cast of characters in them, and the real question is, are we going to trim out some of the things that are said on the people on the side who aren't the main narrative here, rather than have to risk the whole book being pulled because somebody who is mentioned on page 371 threatens a lawsuit later on? And that can be difficult. And also, I think the point, again, that Manuel made later, that if even before you go to a publisher with your prospect for a book, you've had a letter warning you nobody is going to touch you. And nobody's going to touch you not only because they're cautious, but because their insurers won't cover them if they knew there were threats even before publication. And that can be very chilling, because these are the people who most need to be investigated. But it is brave publishers who will be behind you if you've already had a letter saying, if you publish this, we'll sue.
I heard a wonderful story a couple of weeks ago about someone who had exactly that same problem, that they had a legal threat against them and they couldn't find a publisher. And they were talking to John le Carre about it, the late great John le Carre, who got out his checkbook and signed a check and wrote the guy's name on it and said, there you go, take that to a publisher and say, if you have any problems, I'll pay. And they got a publishing contract, no trouble at all. So there we go. You just need John le Carre. On the subject of people who are very generous with money and very helpful to journalists, we have a question from the floor from Flutara Kusari from the ECPMF. Full disclosure, she's being very helpful to me. Flutara, do you have a microphone and would you like to ask your question?
I believe, yes. Hi, my name is Flutara Kusari. I work for the ECPMF, European Center for Press and Media Freedom. We document legal threats to journalists on Mapping Media Freedom and Council of Europe platform on safety of journalists, and we also offer legal support to journalists. I have a question for the speakers. Very often we have difficulties in convincing journalists to speak up about their cases, to document these cases. We ask them whether they want to publish anything, to say anything. And when I say publish anything about these stories, it means facts, not opinions, not comments about these cases. And there is this hesitance from journalists to allow us to document these cases publicly. And I just wanted to check with you and to ask you, why are journalists so hesitant? What are the reasons that they refuse very often to go public about these cases? Thank you.
Shiraz, would you like to start on that one? I mean, that ties into a bit what you were talking about earlier. Would you like to expound on what you were talking about earlier about precisely this same issue?
Absolutely. And I mean, this is part of the reason that I was cautious in not naming any of the parties in this scenario that I sketched out. And I was, texting Dario earlier today, and he was saying that he was looking forward to the day's events. And I said, I'm happy to be speaking about this, but I hope it doesn't poke any sleeping dragons. As I mentioned, the law firm had a 20-page letter, drafted and ready to go, just waiting for us to come back to them once on this issue. So, even now, part of my participation on behalf of Amabungani in today's event is, and Susan, very helpfully pointed this out, the 1-year defamation prescription period that we would call it in South Africa has elapsed, because the articles I referred to were published in September 2020. And that gave us a bit of confidence to come and speak about it. But I would still be wary about publishing, if the subjects that I talked about, do get wind of it and respond again. It's the issue of double slap that was mentioned. So we have to be extra cautious. I'm also, another thing that I was weighing up is the 1-year period in relation to defamation may have elapsed. But what about these data protection claims? What about the claims in relation to privacy? And I'm not, I'm a lawyer by training as well, but I'm not well versed enough in UK law to answer those questions, nor can we brief lawyers just to get, satisfaction. So again, it's the cautious approach, and this is why we're not comfortable to put all of this on record necessarily.
Frans, would you like to talk about that? The dragons, we are in a slightly ridiculous situation, since I think we all know what these dragons are called, but I certainly don't want to particularly poke them with a stick either. Do you agree that there's an issue here with journalists essentially being unable to talk about, let's face it, a genuinely serious threat to freedom of speech, and who's behind it?
Yeah, I agree that is a massive issue, and I think there are a couple of reasons for it. I mean, one is I think a lot of journalists don't necessarily want to sort of talk about themselves too much and go, they just kind of want to get on with the stories. I mean, at the end of the day, sort of our sort of sub stories are possibly less important than the things we're actually writing about. I think secondarily, yeah, there is that kind of uncertainty about, well, what are the kind of legal implications for this? And I actually, before I spoke, I kind of wondered, well, to what extent do I want to name people? Because it's not really about those people. It's about a system and a pattern. And I decided that I did want to because I think there is a little bit of a taboo. And it does hinge on this kind of uncertainty. Well, am I getting myself into kind of trouble? And there isn't really advice on that. And I suppose you can go and get advice, but you don't kind of go and do that when you're just working as a journalist. And particularly, if a lot of the stuff is kind of marked private, confidential, not for publication, you kind of wonder in the back of your mind, well, am I doing something wrong? But ultimately, I agree. I do think, and that's why I think what Foreign Policy Centre and others, Index and Censorship, are doing is so useful, kind of bringing all these experiences together, because at the end of the day, everyone's in their own newsrooms having very, very similar experiences, and we're kind of not really sharing those experiences sufficiently.
Great, thank you. I think we have another question from the floor. I'm loving this question from the floor business. Annika Wodenberg. Sorry about my pronunciation. I'm getting it all wrong today.
Hi, Oliver. Annika van Woudenberg. So a question also following up from what Franz said and from what the panel said. And I work for a civil society organization, so we get some of these letters as well, threatening letters. I actually wonder, well, I have two questions. One is, should we think about sharing these letters? I know they're marked private and confidentially when they frequently arrive in our inboxes, but actually I don't think there is a legal obligation to keep those private and confidential. Could we begin, is this potentially a future project, collecting these threatening letters from the same dragons and starting to put this information together in a way that's helpful to counter such threats? Let's be more informed about what we're all facing and see what we can do to counter it.
Manuel, if we could come to you on that. Now, I know Daphne Caruana Galizia certainly wasn't scared of putting these letters on her blog. She wasn't scared of anything, bless her. But as her fate tells us, sadly, a libel suit is very much not the worst thing that can happen to a journalist. It's compared to what happened to Daphne, obviously a very minor thing. So how do you feel about that? If you keep getting these letters and you feel that they're essentially just bullying you, would you be prepared to publish them, or would you not want to take that risk?
Look, I have. So the Carter Ruck letters before the Daphne book and Jürgen Fenech's lawyers' letters before the Daphne book made an annex into the book because we felt two things. We felt confident in our reporting, and the other thing we felt is that the language used by their lawyers and by the subject of our investigations in response to our questions were an indication that a reader could figure out for themselves without us having to spell it out. They could make their judgment of how these people felt and how responsible these people were. But you still get a mixed feelings about this situation, because there are situations where the risk evaluation leads you to drop a story. And that's not something any journalist will ever speak proudly of. When I spoke about, in my first intervention, I spoke about an apology I published to clients of a bank that had been shut down and they lost a lot of money in the process. And this happened after I withdrew a story because I allowed this bank to bully me. And we allow banks to bully us, we allow these corporations to bully us, we allow these politicians to bully us, because sometimes the calculus, as has been described by the speakers today as well, is that this is not worth the fight. I do not have the means or the resources to fight. And then what we're telling the public is, we know something that you should know, but we are unable to tell it to you. And I don't think anyone is ever proud of that. I think that is a reason for the sort of silence that Flutura was speaking about. So it becomes a bit of a misguided wisdom to be careful and to be quiet. And there's another consideration yet, and I'll finish with this one. We heard from my colleague explain a situation where if you get a legal letter, however substantive it is, threatening you with a lawsuit if you were to publish your book, then they would sue. And because you get the letter, no publisher would touch you. Now combine that with the other principle that we discussed, which is absolutely fundamental, that is that every journalist must double check their sources, but must also give the persons they're writing about the opportunity to respond. So you are obliged, morally, ethically, professionally, to tell them that you're writing a book about them, and to tell them what you intend to say about them, and to invite them to respond. When you do that, you're inviting them, because they know exactly the effect it would have, to send you that legal letter that alone shuts you down and shuts down the book. So there are good reasons why this is a taboo. And that is that we come across information, we investigate information, we establish information, we do our duty because it is in the public interest, but the public is preventing from acquiring that information because of the threats we receive and we are unable to respond to.
Nicola, could we come to you as our lawyer here present? I'm obviously not expecting you to give legal advice to everyone here, but is there a general principle if we receive a letter that says not for publication, does that mean not for publication, or is it just one of those things people write in order to try and get their way?
I think that there were a couple of issues here. I just want to add to something that Manuel and the others said as well about why people sometimes choose not to publish. It's about, particularly again, for authors, when they know that publishers are so careful, they're really nervous about getting a reputation. And one of the things I've learned after 10 years at the Society of Authors are things that we as lawyers may think are not a problem at all. Even the publishers would never do that. Even if we thought the publisher would never do that, and in this case, I think they would do it, authors are very worried about putting their heads above the parapet, about getting a reputation as someone who has been sued and then writing more and banging on about it or whatever, and that they won't get contracts in other areas. And so all of that makes them nervous. And in terms of the law, well, there are various things about what it means by publication, and also, as we all know, about what is the risk that people will come back and do anything about it. Because what would it mean for their reputation if they were to sue you for publishing a letter that you sent them? Whether or not you're entitled to in law is a question, again, that we have to weigh up. And publication, yes, of course, there is a copyright. They own the copyright. So technically, you're infringing their copyright if you publish their letter in full. But that doesn't necessarily mean that you can't paraphrase it or whatever. And it doesn't mean you can't show it to your advisors. And in this case, if what we're talking about is collating letters that come in and sending them to advisors for a real reason, that's very different from just putting them in a newspaper and publishing them for no reason. So I actually think that the idea that we might have a central place where we collect them and think about them and then publish quotes from them later, and where you're entitled to get advice on them, very hard for people to complain, because you'd say, I'm getting advice on it. And for someone to suggest that you can't go and get advice on something, I think would be extremely difficult, and certainly a freedom of expression question. So I would suggest to people, and we do have that. We have authors who won't give us their contracts to vet because their publishers have said it's confidential. And I'm like, that is ridiculous. Nobody can criticize you from letting us see your publishing contract and commenting on it and advising you on it. And but everybody is standing alone. Journalists are standing alone, as we hear, and writers are standing alone. And unless they feel supported, it's great that groups are here. It's great that people do it. And the more we can say, we'll stand with you, send them to us, we'll look at them and we'll share it. Because what's coming out from this room is it's happening all over the world to all sorts of people who don't realize the extent of the problem, and that there are other people there who are extremely knowledgeable about it who can help them.
Thank you. Very, very interesting. And I mean, obviously, the FPC was trying to collect a few examples of these letters, and I think managed to get a few together. But yeah, people are naturally reluctant to take the risk involved, particularly when you're up against very well-resourced and very resourceful legal firms. We've got about 6 minutes left. I thought I might, first of all, there's a question which has come in, someone who's asked to be kept anonymous. Frans, just for you, in when you're facing kind of legal back and forth like you did with the Democratic Republic of Congo story, how do you protect your sources or be sure that you are going to protect them in a situation like that when they are throwing absolutely everything at you to try and figure out who it is who's been talking to you?
Yeah, that's a really good question, and something I don't think I really got into enough. I mean, one thing to really remember is that you've got London lawyers who are basically trying to figure out who your sources are to pass that back to the rulers, essentially, in Democratic Republic of Congo, and those sources are then incredibly vulnerable. So you've actually got these British solicitors helping autocratic regimes and their entourage in persecuting people. So how do we protect them? I mean, you have to be confident in the fact that you do have source protection rights and that you don't have to reveal anything. And you've just got to be, so for example, one thing you've got to be incredibly careful about is, let's say you're writing something based on a document, and then they say, well, we can't really respond because you've sent us all these questions, but we haven't seen the document. And then obviously what they're hoping for is, well, somewhere on the document is a telltale sign because this has got, it's got some sort of a stamp on it, which reduces the pool of people who could have possibly had it. So you've got to be careful about kind of sharing documents, and you've just got to not fall into the trap that's set by these lawyers. And you've kind of just got to stand your ground and say, this is exactly what you know. And you have to be transparent as well. And that's where the kind of balancing act comes in. But you have to be transparent about what the character of your information is, what the nature of your information or quality of the information is, without going into, well, where is this information actually from?
Thank you. It's fascinating. So I just thought we'd finish by talking about what better should look like. What could we sort things out? I mean, Nicola talking about insurance and so on. I mean, the issue is that that's a way of trying to share the cost of these proceedings. From my perspective, the ambition should be to bring the cost down or get rid of the proceedings altogether. So I thought we'd start with you, Therese. Could you talk about what would better look like for you? What would you like to see apart from British lawyers going away altogether? Butch, perhaps, is it?
Yes, as I mentioned earlier, the thing that would be great for us is, the thing that would have given us complete satisfaction would be if somebody offered us, legal representation, pro bono representation, but that's not going to happen. So I think what Nicola mentioned earlier about making sure that these cases are able to be battered away from the courts at a very early stage, that would, definitely give a bit of a boost to the impetus to say, we're going to initially, put forward our response in the, whether it's legally on letters or, engaging in the first stage of litigation with the confidence that it would be taken out of the system fairly quickly. Maybe if there's an alternative review mechanism, so where these types of cases go before they get instituted formally in court, if there's a pre-process, for instance, where someone with a lot of experience in these matters can look at it and advise as to prospects, for instance, that kind of thing would be immensely helpful.
Thanks. And Manuel, I'm wondering for you, I suppose the question is, if we did manage to sort the situation out in the UK, would you just face, like you said, you did legal proceedings from other jurisdictions? Is this an unsolvable problem?
Well, it is a moral problem. It is not just a legal problem; it's also a moral problem, and I think it needs to be addressed morally and politically. In that, what's happening here, the consequences of this, is not just that the lives of journalists can become more uncomfortable than they should be. It's just the public's right to know, the public's right to be informed about what's happening and what the powerful are doing is being sacrificed. And therefore, I think we need to raise awareness of this. I think the public needs to expect from people in public life, from corporations, from big businesses, them not to indulge in this sort of behavior. I don't know if I want to make an analogy, that it is not acceptable to for a corporation to sell textiles manufactured in a sweatshop with child labor. That sort of thing is stopped by the consumer demanding a minimum standard of decency from corporations and from people in politics and so on and so forth. I think the public, certainly it's been said here, not all journalists and authors are aware that so many others are facing these situations. Even less so, the consumers of our journalism, the consumers of our books and of our writings, that are not aware that there's a lot out there that they're not reading, that they're not finding out because of these abusive, aggressive, and anti-democratic behavior by corporations and people in power. So I think raising the public's awareness is an important step that we need to take now.
Thank you very much. I think that's a very good note to end on. Very important. Thank you to our panelists. That's been absolutely fascinating. Thank you very much for all listening. And that's 11:45, and that's all we've got time for. I think that's zipped by. So thank you very much.